We go on now to the second panel of today.
Y bueno, si hay alguien que no necesita presentar.
So, if there is anyone who doesn't require introduction in this conference, is possibly Professor Jordi Ferrer, who is the clear culprit of this conference and of so many other initiatives in publishing, in academia, a number of initiatives that have meant the flourishing of probatory studies, both in Latin America, well, in America and Europe. So a big hand for Professor Jordi Ferrer. Thank you for the organizing and for everything, Professor Ferrer.
Bien, muchísimas gracias.
Thank you very much indeed. In difference to the other speakers, I won't say thank you to the organizers, because that part then of the time of my speech I will save, and I will use the time for a presentation that has to do with the concept and the way in which we can analyze standard of proof and standards of proof in our systems. It has been mentioned in repeated occasions already during this conference. People have talked about a situation that has changed radically in the countries, so to speak, of Latin or Roman origin as regards culture. Maybe we could include that as well to Germanic countries, but not Anglo-Saxon. And what has changed? The situation of neglect that traditionally had been happening in probatory studies, in legal disciplines. And in fact, even nowadays, that neglect is still present in the training of all legal experts in our faculties of law, in which probatory studies are really quite scant and practically most of the times non-existent. But this is not the case in the literature, and this is not the case either in the academic activities, or at least discussion activities such as this one, in which in the last 20 years we have lived or witnessed a gradual flourishing of studies on evidence in judicial processes, both in Southern Europe and in Latin America, and also about procedural guarantees. There has been quite a notable flourishing, especially along the guarantee theories, at least criminal guarantee, Luisi Ferraioli is the leader, or the procedural guarantees with Alvarado, Belloso as well. But, well, in probatory studies, studies that have to do with evidence or procedural guarantees, and also criminal guarantees, I think that even nowadays there is quite an important gap, something missing, and that is the conceptualization and the studying of the problem of standards of proof. It's a gap, it's a vacuum, and I will try to explain in the next minutes, well, why I think it is so serious that we have this lack. And I think that precisely the lack of standards of proof is what leads to the undermining or to the total, well, failure of the rational theory of evidence and also conceptions of guarantees. And attention has to be paid to this problem. What are the assumptions that the analysis begins with? Well, assumptions that I am giving you so that you know exactly where I'm going to be starting from in my presentation. Justification of anything. I mean, if somebody wants to talk about it during the discussion session, no problem. But this is my starting point here. What are the assumptions? Well, essentially four premises that, at least in the general probatory theory, are part of our culture. And I also think undoubtedly that in Anglo-Saxon theory, they can be considered, well, as common starting points for analysis. First, the teleological relationship between the concepts of evidence and truth. That is, that the goal of evidence in the judicial procedure, the institutional aim, is, of course, to find out truth. Truth understood as a correspondence with the world in such a way that a fact that is determined as proven in a procedure is true, not if the judge says so or the jury says so or according to what happened during the trial itself, but rather on the basis of whether it corresponds or does not correspond to what has happened in the world. That doesn't mean that it has been proven or not according to that. Evidence has to do with the procedure, but truth has to do with the world. Despite the fact that the aim is to find out truth, we have to be well aware of the fact that never, ever, ever, when we talk of fact, not so much in the process, in the trial, and in law, but in no category of knowledge, can we get to rational certainty about what took place. We can never have absolute rational certainties. Psychological certainties, yes, every one of us has a number and they help for us to live better with ourselves, but they are not relevant as a justification. So rational certainties are never there. However rich or reliable and abundant, this will never allow us, this certainty. So then necessarily the conclusion of probatory reasoning must be a certain probabilistic support in that hypothesis that we believe has been proven or not is true. So probatory reasoning is necessarily structurally a probabilistic reasoning, but a probabilistic reasoning that does not respond to a conception of mathematical probability. So then in that way we cannot apply axioms of mathematical probability. So then we cannot reason during a judicial procedure in numerical terms. And this indeed has crucial importance when we formulate standards of proof, because those standards of proof cannot be formulated either in numerical terms. So from these four premises, we see the need of actually formulating standards of proof. We see the need because if we cannot have absolute certainties, if we cannot have rational certainties regarding what took place, well then we can only conclude that there is a certain degree of probability regarding the fact that the hypothesis is true. But what degree of probability is sufficient to accept the hypothesis? What degree of probability or corroboration, if you'd rather express it this way, is sufficient, is enough for us to say that a specific hypothesis about facts is proven in the procedure? If we don't determine what that degree is of sufficiency, which is what standards of proof target, well then we simply and honestly can't determine when a hypothesis has been proven and when it has not. But there's more. We can't really play, or at least take to the trial's chessboard, so to speak, are the rules with which we usually work. We can't really, in the trial, use rules such as the burdens of proof. I mean, what is a burden of proof rule giving me? Well, essentially, it's telling me who loses if there is not sufficient evidence. But if I don't know when there is sufficient evidence, well, then really I cannot apply the rule of the burden of proof. In the criminal procedure, but not only there, this is made worse by the fact that the same exact thing happens with specific assumptions, or most assumptions, but especially during a trial with the assumption of innocence, in dubio pro reo. When in doubt, if there is not sufficient evidence, then one must not sentence the defendant. But when do you have sufficient evidence? And in other terms, when the sentence of the defendant would violate the assumption of innocence because this would have taken place without sufficient evidence. So once again, if we don't know when there is sufficient evidence, we cannot determine when the assumption of innocence has been complied with or when it has been violated. But the same happens with any other kind of procedure and with any other kind of assumption Because, of course, if it's juris tantum, I mean, juris tantum assumptions as rules that can be falsated, that is, rules that establish that one must assume a certain fact. If a basic fact is accredited or not, that depends on the kind of assumption. Well, except in the case of the contrary evidence, well, then they require that we have indications of when there is contrary evidence, or in other terms, when there are sufficient elements of judgment to consider the hypothesis as confirmed. So do pay attention to the fact that the very crucial elements of probatory reasoning that have direct consequences as well on the judicial motivation, that is, on what will have to be justified by the judge in his or her judicial resolution to understand that the decision then has been sustained adequately in law. Well, without standards of proof, we see the occurrence of a total and absolute lack of pillars or foundations of this building. So that is, we don't know when the innocence assumption is happening. We don't know when the burden of proof has to be used or not. We don't really know anything. We don't know when the hypothesis has been proven or not if we don't have standards of proof. So then without standards of proof, we can't really get the rules to make decisions in a trial work. And the fact that we cannot have rules working during the trial regarding the decision to be made means very clearly that we have a huge problem and we are being arbitrary in decision making. This has not usually been seen by the different doctrines that I mentioned before. Very little work has been done on general probatory theory about standards of proof in our legal culture, not in others. And it has been directly ignored on behalf of people defending procedural guarantees, who indeed say nothing at all about this, as though the in itinerary guarantees during the procedure were sufficient, and never mind what happens at the end. But, my dear friends, I think that really what is most important is the guarantee of how the decision is made during a trial, and later on we'll go to other things. But, I mean, if we are deciding on the basis of something arbitrary, well, then the previous guarantees are useless. So what are the most common mistakes that we find in our systems when one faces the problem of standards of proof? Well, essentially, and at least those of you who come from countries with Latin origin legal systems, you will very, very quickly find the examples in your own systems. And I would add Anglo-Saxons as well. Please have a look. Two kinds of problems. On the one hand, rules that essentially have to do with subjective elements. The intimate conviction, the moral certainty, the conscientious assessment, and this beyond reasonable doubt. If this reasonable doubt depends on the psychological state of doubt of the person deciding, and we don't have reasonability criteria of doubt, all these then are criteria for decision-making that are present in jurisprudence and typically are in our systems, as well in legislation or legal systems. These are decision-making criteria that directly go to the subjective side of the person making the decision. But if these are criteria that depend on the subjective opinion of the person deciding, whether it be the judge or jurors, well, then we can't really purely talk about standards of proof. It's not a rule that establishes a standard, really, and there are no intersubjective control mechanisms regarding the correction of the decision. Second fundamental mistake, that those so-called standards of proof, in fact, are not even inaccurately giving thresholds for good decision-making. As I was saying a moment ago, probatory reasoning is based on probability. We have to determine the level of probatory sufficiency in order to make decisions about the facts. But this means to establish some kind of criterion that even in the case of its not being as accurately as numbers and mathematics would tell me, it would establish a threshold beyond which we might consider the hypothesis probable and below which we cannot consider that the hypothesis has been proven. Of course, calling criticism and induction in for better reasoning another criteria such as these, or even using the science of logic that so many of our systems want to use, are not either criteria that give us any kind of threshold whatsoever. If by induction or healthy criticism, never mind, call it what you may, well, we say that it's always we talk that all the decisions are made on the basis of an inductive reasoning, but we also decide on oral trials based on inductive reasoning, and also when we go for cautionary measures such as the provisional prison sentence or the decision to sentence or absolve. But when all those decisions are made on the basis of inductive reasoning, well, then of course the level of evidence reasoning there is not working. So it means that when we talk about induction or criticism or the laws of science or logic, we can't give them as arguments to determine the thresholds. They don't serve. Decisions, we say, have to respond to those criteria, but those criteria are not giving us any kind of threshold, so then they are useless for what, in fact, I am trying to justify here. Please allow me to give you a couple of examples now to see how this is happening in our communities, but I have my documents on the table. Allow me. Two examples. Article 641 of the part of the penal law in Spain on overseeing the cause that will have to be adopted in different situations. The second says, literally, when it transpires that an offense has been committed and there are insufficient grounds to accuse a certain or certain individuals as perpetrators, accomplices, or aiders and abettors, and when there is no insufficient grounds. Second, Article 503 of the same criminal procedural law that regulates conditions in which the accused should be provisionally remanded in custody. Well, these are different conditions, of course, and one of them says as follows. Well, that the case presents sufficient grounds to reasonably believe that the person whose imprisonment is to be ordered is guilty of the offense. In a case, so insufficient grounds, and then sufficient grounds. So yes, fine, but gentlemen, when does this sufficient grounds happen? And when are there sufficient grounds to believe? That is the problem. You can't answer a question repeating the question. Come on, you can't respond to the problem of determining the degree of sufficiency by saying when they are sufficient, when they are enough. Our legislators, frankly, have not actually done their homework. But they have not done it because our legal culture, much before the legislators, I mean the kind of lay jurists, have not really done our homework either by developing an adequate theory of standards of proof. What criteria should be complied with by a standard of proof theory for it to be well formulated? Different to what I've just mentioned. Well, a standard of proof theory has to actually fill two types of reasons or requisites or criteria, methodological on the one side and political on the other. And very clearly, of course, they have to be distinguished because obviously those that are methodological can be studied by theory on how we better formulate standards of proof, whereas those that are more political have to be the basis of study of the decision of legislators or authorities making political decisions in each country. But one has to perfectly understand what the scope of each is. And that is what I'm going to develop in the coming minutes. Regarding methodological criteria, there are essentially four. And you have them here on the screen. The first one is the standard of proof, or standards of proof, have to be related to criteria that have to do with the justification ability of the probatory heritage regarding the decisions made. So this connection, they have to be related to up to what extent they have to give us some kind of criteria regarding to what extent the evidence existing in the file justifies the decision. I said already that this was something based on probability. It's kind of gradual, fine. But then to what extent, precisely? To what extent? We're talking of a measure. So to what extent these elements of judgment justify the decision? But this doesn't happen when the so-called standard of proof relates to subjective elements of who's making the decision, beliefs, convictions, principles, absence of doubt of the person deciding, because beliefs, convictions, or absence of doubt is saying nothing at all about the justification ability of the evidence. Nothing at all. And even if we had some kind of mechanism in order to have a good scrutiny in a kind of neurological evidence, to have a scrutiny to see whether the judge is really well convinced or sufficiently convinced or firmly convinced on what he or she declares as proven, well, then that convincement is totally irrelevant regarding the ability of justification of evidence regarding the decision. They are private facts of the judge, so he can tell his kids or his wife or his parents, but not in trial. Nothing at all justifies the conclusion, the probatory conclusion. But not only then must it be related to the justification of the decision when there is this evidence, but rather these criteria should have the ability of establishing or determining a threshold of probatory sufficiency. Obviously, the first of the elements, the first of the criteria would be complied with and would be met with a criteria stating that has to be an inductive relationship between evidence and the conclusion. But the inductive relationship between evidence and the conclusion doesn't give me a threshold. It's just saying something about the method or something about the kind of derivation that we establish from one to other. But it's not establishing a threshold, and so it would not comply with the second of the requisites. Third, that threshold cannot be established from a standpoint of a methodology of mathematical metrics or mathematical probability. As I said already a few minutes ago, we cannot establish the threshold saying when probability goes over 0.8 or 80% or 0.6 or 60%, call it what you may. We can't give this kind of threshold because probatory reasoning cannot be translated quantitatively, or at least not in mathematical probability terms. But it's not only this. When we are thinking about determining standards of proof, we have to be well aware as well of the fact that the judicial procedure, be it civil or criminal or I don't know, whatever type or whatever jurisdiction, has a certain progression in its development in such a way that we make decisions on facts at different procedural moments, and not only at the end in the sentence moment. We make decisions on facts, as I said before, and furthermore, I've given the example of those rules of the criminal procedural law. Well, we make decisions on the facts when we determine whether we're going to oversee or not, and we do it also temporarily, or well, we make decisions on cautionary measures, on facts when we go for oral trials, and also at the end. And such decisions have to have their own standards of proof, but those standards of proof have to be different. They can't be the same, because if they were the same, well then, when we made the first decision during a trial, we would be preconditioning what the final decision will be. So there has to be a kind of progression between the first standards of proof, a progression as to the level of probatory demand regarding first standards of proof and the last one in a trial, in a procedure. So we have to make a political decision first of what the final standard is, and then on the basis of this we can make decisions as to what are the previous standards of proof that have to be necessarily, of course, of a lower demand level than the last. Then all this, of course, makes it impossible to determine what the standards of proof will be. Alex Stein insisted in his book on philosophy proof, on philosophy of evidence, he insisted on that epistemology cannot determine the degree of demand for standards of proof. And I think that that is a perfectly valid argument. It wasn't only mentioned by Stein. It's just perfectly correct. And this is because to determine what the level is of probatory demand that we're going to require for each kind of decision about fact during the trial or the procedure requires political decision-making, not only epistemological decisions or methodological decisions. And those political decisions respond to preferences for different subjects, and at least some of them I'm going to mention, that have a lot to do with the decision of the level of the standard of proof. With these 4 that you have on the slide in the screen, I'm not giving you a full list of all these subjects and concepts and notions that have to be taken into account, not at all, because remember, they are political reasons or political moral reasons. Very possibly there are others, and even in some cases we might defend that some of these we're not really interested in. But it would seem, yes, that these are, well, subject or notions that we should take into account in order to make that political decision as to the level of demand of the standard of proof. First consideration of political or moral criteria, the seriousness of the error of a false sentence or wrong sentence. That, of course, it plays a role, a crucial role, in that it determines what our aversion or abhorrence is. We don't want to make the mistake of being wrong in sentencing. I mean, it's not, the seriousness varies completely when one is making a decision about choosing one street or another to go to the closest shop. It's very different from making a decision and then finally making a mistake in the decision made on whether we're going to be operating on a tumor or no that has been recently diagnosed. Our decisions in our everyday lives have different outcomes and different degrees of importance according to the outcome, and the possibility of making a mistake in that decision-making will be affecting our life in different manners. And the seriousness of the mistake, if we make the mistake, is something that we take into account when we consider, well, I have to have better reasons to make this decision. I must have more probatory or evidence elements in order to make this decision, whether I operate or not, and that more than in the case of choosing the street on the left or the right to get to the closest shop. So, and what about the seriousness of the error in false sentences? Well, there are some when there is a financial fine, even of a very small amount of money, and then you have wrong sentences in professional situations. You have a false sentence when for space separation. There are 20 years in prison also through a false sentence. So, well, you name it, so many different examples, and not only in different branches of jurisdiction, but also within the same one. The implosion of criminal law, at least in our countries, in our southern countries in this last decade, is a kind of punitive populism. Yeah, it's all done through penal law. But then that means as well that there is an increase, a substantial increase of the amount of types of sentences that are the direct result of the penal procedures. Not only privation of freedom, where it exists, there's also the life sentence, the death sentence, but there are many other different penalties and of different levels of seriousness in that it affects legal goods, and very varied. Sometimes it's freedom, sometimes it's freedom of movement, sometimes it's being able to work, and so on and so forth. So, how serious is the mistake if we are sentencing falsely? It depends on the anticipated legal result, because of course the more serious the error, if we make a mistake in the sentence, well then this makes us want to have greater grounds for the decision. So then it makes the standard of proof be more demanding and more important. But there is also another kind of mistake or error, which is false absolution. It's not false acquittal, because there are different degrees. I mean, and we have false acquittals definitely but acquittal is not only the ones that take place at the end of the procedure, finally, but all those that are made in preliminary phases of cases that don't continue, okay, but regarding persons that, yes, indeed, have committed the act that they were being judged for. So in those cases, law is not really complying or meeting the need that we want law for. And if we talk about criminal law, we don't only want criminal law and for the state to work in criminal law. We don't want it only for innocent people not to be harmed. If that were our only aim, the best way would be to do away altogether with criminal law. Just do away with it fully and don't have any criminal courts. So then we would never be making mistakes, making innocent people end up in prison. So if that is the only aim, let's do it. But of course, it's not only that. With criminal law and the action of the state through criminal law, we want much more. We want to protect our physical freedom of movement, our sexual freedom, our heritage, protect it from bad acts that third parties can actually carry out. And that's why we invented criminal law and the action of the state through the criminal procedure. And so it's that second aim of protection that's important, and we wouldn't obtain the protection if we did away with penal law or if we had such high levels of probatory demand that it would make it impossible to apply the anticipated legal consequences. So then it means we have to take into account false acquittals, but false acquittals don't have the same degree of seriousness or severity in all cases. What is the level of reincidence regarding the illicit acts that take place in that specific situation, and in what way a false acquittal will affect regarding the motivation ability of law? There are different situations that would make false acquittals being more or less serious. Obviously, the second reason, then, well, the more concerned we are about false acquittals, well, then the more it's going to get standards of proof to go lower towards less probatory demand. Why? Because the standard of proof is not really there to reduce the mistakes that we make during the procedure, but rather what it does is distribute the errors that are made. The more demanding the standard of proof, the less sentenced innocent people we will have, because it will be more difficult that with an innocent person, such a high degree of level of evidence will be reached because of the standard of proof. But at the same time, we will have more culprits in freedom, because of course it also applies to people who have committed the acts. And I mean, I'm using innocent and guilty in the sense that, yes, they have been or not the people committing or not committing the act. But then the more difficult it will be for these guilty persons to actually go to prison, because there's this very high level of standard of proof to be acquired. So then there are few innocent people in prison, but many guilty people not in prison. If we lower the level of standard of proof, the contrary thing happens. You'll have more innocents in prison and, also more guilty people in prison. It's very simple, but it helps us to understand that the standard of proof has this role of distributing errors, judicial errors between the two types of parties, but not only seriousness of consequences regarding false acquittals and false sentences. It's not only this that we should take into account. What I also think is very important is to take into account the probatory difficulties of the kind of cases, not the specific case we have to judge, but rather the kind of cases that case belongs to. Let me give you just a couple of examples and you'll understand it easily. In practically all our countries, there has been an evolution in criminal law regarding the protection of sexual freedom, and this has to do with the crime of rape. And there has been an evolution in recent decades, clearly, because the worry is increasing concerning the integrity of the ability of all of us of consenting or not to a sexual relationship. So that's where the the weight of it all is focused. If you go back in time, 20, 30, 50, depends on countries, we could easily find legislations in which, in order to consider that the offense of rape was being committed, the victim, typically a woman, but not always, the victim had to accredit that she or he had said no and had opposed physically the sexual intercourse act, understanding that if that resistance had not existed, well, then implicitly she or he was giving consent. However, nowadays we don't understand it this way. We understand that it is sufficient with an explicit lack of consent. So it's just enough to deny the sexual relationship, and this can be expressed, this negation can be expressed orally or not, but what is enough now is the lack of consent. We don't demand physical resistance of the victim as we did before. But of course, this changes things from a probatory standpoint. Yes, it has clear consequences. So what is this causing? It was much easier, probatorily speaking, when we demanded physical resistance, because typically physical resistance, yes, did leave physical signs on the victim and sometimes even on the offendant. And now, however, very often the issue of whether there has been a rape or not is decided on what is stated by the victim against what is stated by the defendant. So the victim saying that he or she did not consent, and the other person saying, yes, it was a consented sexual relationship. And of this, there are usually there's no evidence left, or very, very scant evidence. So we make decisions in a situation in which the penal category or typology takes us to a situation in which we have to decide on things with a very low standard of proof, or at least a very small burden of proof. If to that we add a demanding standard of proof when there is very little evidence, well, then everything will be useless, really, because in that situation we will never ever get to the level of demand that has been anticipated by the standard of proof. Probatory difficulties of the types of cases can be useful to actually play in favor of lowering the demands of the standard of proof, so moving it kind of more to a grassroots level. So, of course, these different reasons can play in opposing senses as well. What might happen is that we have a situation of probatory difficulty, and then the standard of proof would seem to kind of go down towards greater simplification, but with high sentences anticipated. So then that would move it up. We don't have any answers, at least not theoretical answers, for the combination of such reasons. It's really a political preference that's at play. So in every society, at every given point in time, we have to make decisions regarding, what is happening, and taking into account all these reasons, what the standard of proof is that we consider reasonable. But listen, let's make the decisions. That's the best, because if we don't make the decisions, the judges will case by case, and in the worst case, furthermore, they will not tell us with what standard of proof they are judging, because this is the way that typically things happen. But to make a decision about the standard of proof, we have to also go to analyze the standard of proof and other rules of decision making. There are a number of different rules that contribute to the distribution of probatory risk during the procedure. Not only standards of proof, the burden of proof distributes the probatory risk among the parties. The person with the burden of proof has more risk in that sense than the one without. And then assumptions in processes in which there are legal assumptions, they also have that same effect. We cannot not know in the moment that we determine the standard of proof what the distribution is of probatory risk, taking all the other rules into account. Imagine that we decide to alter the burden of proof legally. Yeah, we decide to change the burden of proof in trials for civil responsibility for defective products, establishing that the burden of proof has to be put on the shoulders of the manufacturer and not the consumer. A manufacturer that typically will be the defendant, and the consumer that will be the actor. So we attribute the burden of proof to the defendant and not the person putting, and not the claimant. So then see what happens. But at the same time, establishing a standard of proof that's very, very low and so easily met, or, well, that the entrepreneur, in that case a manufacturer, can easily meet. So then if the initial goal was to have a regulation more favorable to the consumer, well, then this combination does exactly the opposite. So the goals that we are looking for, according to the distribution of risk of error between the parties, must be taken care of, taking into account not only standards of proof, but also all the different types of rules that have as a specific role the distribution of the risk of error. And these at least, not only, but these at least are burdens of proof, assumptions, and standards of proof. So with all this at play, then what can we do? If we take methodological or epistemological criteria into account, well, we could already realize that most, if not all, formulations that our procedural legislations and our jurisprudences have about standards of proof are not really meeting such criteria, and that means that they are not satisfying the demands that should be put forward by a standard of proof. They are not meeting this conscientious assessment, induction, the compliance of scientific or logic laws. None of these work, and not even a subjective interpretation of this, beyond any reasonable doubt, and not even with the preponderance of evidence, if preponderance of evidence is considered in such terms as it is dependent on elements that have to do with mathematical probability. So we have to have a departure point somewhere else. And it's normal when one is talking about this in auditoria such as this one, that the inevitable reaction of people is, well, then what? How can we go about this? And what comes now in my presentation is not going to be an indication of what should be standards of proof, because none of the 6 formulations I'm going to show you, none of the 6 wants to have or has the pretension of indicating what the standards of proof should be in a specific procedure or at one stage or another of the trial, but rather they act only as examples of formulations of standards of proof that, in my opinion, do meet the requirements, the methodological requirements, and that could be selected according to the combination of political reasons prevailing in every case. I will show you, as I say, 6 formulations of standards of proof that go from greater to lesser levels of probatory demand. This, in fact, now is the most demanding that I can think of, and, well, it's even been jurisprudentially translated in a way. Have a look. If instead of Article 741 of the Spanish procedural law that establishes that the judge will value the evidence in conscience, and that's all that is said about the assessment criteria, if instead of it we had something like this in the same law, in order to consider hypothesis of the facts as proven, the 2 following conditions have to happen simultaneously. First of all, the hypothesis must be able to explain the available data, interacting them in a consistent manner, and any prediction of new data that the hypothesis allows to formulate must be confirmed. Any hypothesis on facts makes it possible to have predictions about new data, or makes it possible to have derived hypotheses. If I have the hypothesis that, well, if Daniela has the hypothesis that I shot a gun 5 minutes ago before entering the room, well, then we might predict, on the basis of our knowledge of the way weapons work and on the basis of our knowledge about the kind of chemical reactions that happen with certain products, that if my hands and my clothes are tested with certain chemical products, we will find remains of gunpowder. Well, that hypothesis allows for a prediction, and meeting that prediction will corroborate the hypothesis. The first then of the clauses states that the hypothesis must be able to explain in a consistent manner available data, because any non-consistent hypothesis is false. And at the same time, it has to be able to predict new data, and these as well must have been corroborated and contributed as evidence to the trial. But that's not sufficient, because maybe I have remains of gunpowder in my hands or clothes because before coming here, I was hunting rabbits somewhere else on the other side of the river. And so I don't have this gunpowder because I shot my enemy during the coffee break, but rather because I was hunting for rabbits before I came to this session. So then, meeting this prediction that I will have gunpowder remains in my hands and clothes is not sufficient as proven. Second clause. All other plausible hypotheses explaining the same data must have been confirmed. Plausible in the sense of them being compatible with our knowledge about what the world is like. So explanatory of the same data and compatible with the innocence of the defendant. So then, yes, well, we have to have elements that rule out the hypothesis that the gunpowder remains are of having shot rabbits and not of having shot my enemy. Yeah? So this is very, very demanding to have evidence elements that prove that all the other plausible hypotheses explaining the same facts are false. It's a lot to ask for. But let me tell you, it is the way in which quite a lot of the Portuguese penal jurisprudence is interpreting this beyond reasonable doubt thing. Very demanding. So demanding that I don't think any rape crime is sentenced on the basis of such a standard. None of these especially probatorily difficult crimes. But if you think it's a very high level of demand, we can lower the standard of proof. The second clause, the first is exactly the same as the one I just read, but the second clause has a crucial difference. Short in words, but important. It's not anymore the case now that we are rejecting all the other plausible hypotheses compatible with the innocence of the defendant, but rather the hypothesis compatible with the innocence of the defendant formulated by the defense or by the other party if we were in a civil trial. So that, of course, means that we've lowered the standard quite a lot. This standard requires much less than the other. It gives a probatory or evidence threshold that's much lower than the first. And if your political preference are still in favor of going to a lesser level of demand, well, then I go for this one. A hypothesis of fact will be proven when the two conditions happen simultaneously. The hypothesis is the best available explanation, and we will have to have criteria as to when an explanation is better than another. So best available explanation of the facts, the event of which we're trying to prove with the existing elements for judgment in the file. And second, that the weight of evidence of all the relevant elements incorporated is complete, or at least close to complete. What's important here is to focus, well, for 30 seconds on this probatory weight that has to be distinguished from value. It's probatory weight in Keynesian terms, and we see it as the completeness or the comprehensiveness, we are told by Susan Hack, yeah? The comprehensiveness of the whole set of the elements of the evidence. So if in the whole set of the elements of evidence are all the relevant, is all the relevant evidence we need. So I think then that the demand of the probatory weight can be indeed a fundamental element to overcome one of the criticisms that Lodin gives to the use of inference of the best explanation as a criteria for decision-making. René Loudon is criticizing authors that have used this strategy, such as Ron Allen, in that the best explanation can be, despite everything, a bad explanation. if that better explanation is better because it has a bit more of evidence in its favor than another, but that bit more of evidence in its favor is really, really very poor, very insufficient regarding the hypothesis of we have nothing, or regarding the contrary hypothesis, we have just a weeny bit of evidence in its favor. We would consider then this as evidence, but if it's of course only a comparison between hypotheses, one is a better explanation than the other. The demand of the weight, of probatory weight, I think explains this problem. And now I'll accelerate. The hypothesis about facts is proven when when we have the following conditions happening. The second is the same as before, but the first has a fundamental difference. It's not stating any longer that it's the best explanation in absolute terms, but rather, comparatively speaking, the one formulated by the contrary party. So once again, this means that we are lowering the standard. 5. The hypothesis on the facts will be considered as proven in a trial when it's the best available explanation of the facts that we are proving on the basis of existing elements for judgment in the file, but without referring now to the weight. And of course, we have lowered the standard a lot. And 6, the hypothesis gives a better explanation of the facts that we are trying to prove. Then is that the hypothesis of the other party, but once again without the demand or the weight of fact. In the written presentation, and I don't have time to give it you in greater detail, but in the written presentation, analysis of some jurisprudence, specifically on the Human Rights European Court, about the assumption of innocence and the impact of this in the judicial decisions, that would show, at least in my opinion, a deep lack of knowledge on behalf of the European Court of Human Rights, but I mean, it could be made extensive to many other courts, as to the functioning of standards of proof and the role that standards of proof have in the procedure. I mean, essentially, in my opinion, it shows the lack of knowledge, but essentially of two very important things. First mistake, the assimilation in that assuming innocence is necessarily linked to a very demanding standard of proof. Assuming innocence, well, obviously that we have in all criminal trials and procedures, but if I am right in the political elements that I put forward to you here, taking into account the seriousness, the severity of the relative mistakes of false acquittals and false sentences, well then we could perfectly well have different standards of proof for different types of crimes and offenses in the same penal procedures, in the same procedure. So then this assumption of innocence isn't necessarily linked to one single very demanding standard of proof. Second huge mistake, to understand that once we've made a decision in the criminal procedure regarding innocence because of a lack of compliance of standard of proof, so innocence because the standard of proof is not being met, well then this links us to any other procedure in which there could be consequences out of the same facts. So, for example, the European Court of Human Rights, in a case that's not the one in the written sentence, but that, yes, is a good example, has decided that an individual who was made redundant by the company, a company of security guards, because the company says that the man that was driving one of these vans that pick up money from shops and banks, well, that man had actually stolen $10,000 of the money that he had taken, and the man is made redundant, he's sacked. Then labor law procedure is started because the man wasn't in agreement with this redundancy, but then of course the thing continued because of course if he had stolen $10,000 that was a crime. And in the criminal procedure the conclusion was that there was not sufficient evidence, and so he was acquitted. In the labor trial, well, redundancy was considered correct and legitimate because the judge of this labor trial considered that yes, there was sufficient evidence of the guilt of the defendant. The European Court of Human Rights says that the assumption of innocence has been violated because once we've decided that there is not sufficient evidence in the criminal procedure, well, then that decision should link up to all the other procedures and trials that the person would have facing the state for the same events. And I think that this is a terrible, terrible mistake of concept. The reasons that we have to place the standard of proof at a specific level in the criminal procedure or trial is not the same as the ones we have for this standard of proof in a labor procedure. So nothing should move us to make a decision in a criminal procedure than a labor procedure. I mean, not to understand this is not to understand how standards of proof play their role. Thank you.
Muy bien, abrimos la discusión.
Okay, thank you very much. We open the debate, Q&A session. So there is a word asked here, and then on the fourth row also, someone asked the floor.
Buenos días.
Good morning.
Soy Enrique Ballines.
My name is Enrique Ballines. I'm a teacher at the Complutense University from Madrid, and I really would like to congratulate Professor Ferrer. Your presentation was awesome, incredible, and I do share your concern with the subject, because it's true that in countries like ours, we have not paid enough attention to the standard of proof. I would like to ask you three things, very briefly. First of all, question of terminology. When I have read about this subject in Anglo-American studies, they use the expression standard of proof, quantum of proof. But I like a little bit more another expression, like standard of persuasion, which is an expression that they use also. And I think it's more graphic, the standard by which someone is persuaded about the truth or not of a statement. So could we talk about standard of persuasion instead of talking about standard of proof? Second question, this has to do with the difference between three categories, or standard of proof, first, second, burden of proof, and then assessment of the proof, of the evidence. And I think that you very well explained the difference between the standard of proof or standard of persuasion and burden of proof, on the other hand. But I thought, or I understood on your saying, on your wording, that you were suggesting somehow that developing the concept of standard of persuasion or standard of proof, we could maybe avoid the rules of logic and reason as assessment criteria. And I don't know, maybe I understood you wrongly. I don't know. Maybe instead of talking of conscience, I don't know, I mean, can we really replace the traditional dogmatic about standard of proof by something different? And then the third question that I wanted to ask you has to do with the relationship existing between what, to the best of my knowledge, Anglo-American people call the standard of review, that is the standard of review by some kind of expedient, because you were asking the standard of proof to be objective and not subjective. You even were talking about understanding beyond any reasonable doubt. And I thought that in your words there was the will to have an objectivation of the standard of proof with the aim that if there is a claim, a superior court can decide whether the lower court did really correctly apply the standard of proof or standard of persuasion. But this is also a political decision. I mean, the knowledge of the Supreme Court might not be the same. I don't know if I'm making myself clear, But for what I know, and it's not much, says the speaker, in the States, or in general in the States, for instance, United States, the standard of review, I mean the possibilities to review the standard of proof with the facts, is very limited. Is just for what is clearly erroneous. So the standard of persuasion or standard of proof in these Anglo-American countries is also subjective somehow, because it's limited to the decision made by the first level judge. I don't know whether I made myself clear. And then, excuse me, but if we need time for other people to speak. Okay, I leave it here. But something similar is happening in the criminal procedure, in the Spanish criminal procedure. For mediation, we say that the Court of Appeal has some limitation. I think that some light, has left you blind somehow. I'm sorry about this. No, I don't like at all the expression standard of persuasion. Sorry to disagree, but it's a question of taste, of course. Why I don't like it? Because of the use of the word persuasion. That is appealing to a very subjective element. The standard of proof, on the other hand, has nothing to do with persuasion, with the element, with the subjective element of the decision maker. So that's why I prefer not to use that expression, which on the other hand is very common, in particular in the Anglo-Saxon world. I do not think that the standards of proof really suppress the standards. I think that when you try to assess the proof, you are assessing a set of elements. But of course, this does not allow us to make a decision, because in order to make the decision, we need to know whether the degree of corroboration is right or not. If we take the example of the security guard that took $10,000, one could imagine a situation in which two courts, or even the same court, if that was part of the design, two courts would reach or draw the same conclusion as to when they corroborate the hypothesis that the person took 10,000 euros and the elements of proof in the professional, laboral, and the criminal. They do both agree as to when they corroborate the hypothesis, but the standard is different. So we could draw the conclusion that in one case, the hypothesis of the person being guilty is not proven, while the hypothesis is proven in the professional court. Even though when assessing the evidence, they were supporting in the same degree the hypothesis. So the assessment of the evidence depends on the elements of evidence that are available, but we need the application of the standard of proof to see whether it's enough or not. There are different layers or levels of the evidence reasoning, and you are right when you ask what's the standard of proof, and the standard of proof will allow us to see whether the decision was right or not. And another thing, a different thing, is whether we want to control that. And we can decide in the procedural way of working of our system when we are going to control and when we are not going to control. And one can perfectly decide that this is only going to be controlled when there is an error that in our own jurisdiction we are using for certain decision making, and it's not going to be controlled when the error is not a clear, very clear cut case. So it's different when we establish the requisites for a revision, for a review, or not for a review. But having a standards of proof, clear standards of proof, makes the situation controllable. I mean, it's possible to control, and then we'll see whether we're going to control or not. Okay, I see Different people have asked the floor, so we're going to gather different questions. I would like to ask you to be brief, and we will see whether we have time for more afterwards. In the third row, please. Thank you, Jordi. My question is simple. You assume that there has to be a linguistic precision in the in how the standard of proof is defined, because otherwise there will be difficulties in different legislations, Spanish or others. So the linguistic precision, what's the extent of it in the formulations? And I'm asking because in different versions of your work, you had said that should need to be the highest possible degree. I mean, very, very precise. And I think it's good that this is not there anymore, because we could have the false impression of a naive point of view. Of course, we can lower linguistic ambiguity, but we cannot suppress it. Then, if the formulation is really vague, then what do we have? So I wanted to ask you, shouldn't we think the extent to which the level of precision should be? Because otherwise we have the risk to be in the kind of anything goes. I mean, otherwise the judge is so constrained and limited that she or he needs to make a decision according to the facts in a very limited, restrained way. Thank you. Should I answer now, or we gather the questions? Yes, we gather the questions. We go for the questions all together, and then we go for the answers, please. Thank you, Jordi. My question is more or less related to the last one, but it goes a little bit beyond of the linguistic issue. You're saying that formulating an objective standard needs to appeal the justification capacity of the evidence, and I do agree. I think that the idea of a standard of proof gives room for the assessment of the evidence, but there is a link between the assessment system and how the standard is established. Because then the standard needs to answer to epistemic questions or issues. So your proposal, I believe, is that only using epistemic terms, the politic judgment can be made, as if these epistemic characteristics could be there for value judgment. And I wonder whether this is possible, because I think that the standards that you propose from 1 to 5 depend on the case, and they might be compatible with the same set of elements of evidence, depending on how the judgment is distributed or the risk of error in each case. I don't know whether I'm clear or not. I mean, the same set of evidences can be introduced in all the standards, depending on the judgment of a value made in every case. So that depends on the seriousness of a false conviction or the evidences. And those difficulties are not there only for the legislator, but also for the judge. So I think that standards that you are mentioning do not make a judgment of value, but depend on the judgment of value by the judge when making his or her decision. Last question. Please decide between the two of you who is going to ask the question. Let's see whether we have a possibility for more questions and room for more questions. Time. Please, I hope you will understand that we have some time constraints. Thank you. You're proposing several methodological or epistemological criteria to appeal to criteria related to the capacity to justify in order to control, and you are proposing moral and political criteria. But I think that those criteria are just leaving aside the arbitrarity or discretionality, and would rather adopt an intersubjective reasoning. And I think that could change the second premise of the theory of the truth to an intersubjective theory of the truth. So the criteria that you are proposing would not change that premise of the theory of the truth? That's the question. I start by the end, and then I go to the beginning. No, because those criteria are proving when a hypothesis is proven, not when it is true. And when the standard of proof is satisfied, then it's proven. And we have decided to which extent the hypothesis has to be agreed for it to be proven. So what level of corroboration we agree to think it's true. But these are different things. I mean, it's true in the sense of truth by correspondence and in our reasoning, because we never can be sure whether it's true or not. We need to have practical decisions or reasons to establish or state the degree of corroboration. Then I think that, to my conception, there is an ideology of division of powers, division of legal work and legal work. But not only that, but also an idea of a standard. And we can see that because the standard of proof, I believe, has to be determined in the procedural codes, and therefore this is because being the result of a political decision about the risk of error between the parties, it's better the decision to be made by the legislator than the judges. But from the conceptual standpoint, I think that we can understand here that there is a notion of standard. If the level of evidence demand is established by the judge, then the decision depends on the particular case. There is a particularity, but not a standard. And the notion itself of a standard of proof, the notion of a standard itself, demands that ponderation of how different values are translated regarding the distribution of the risk of error among the parties or between the parties according to cases and not a particular case. And that means that at a legal level and not jurisprudence level. If that decision is made from the jurisprudence point of view and is used for any kind of case, because then there are precedents that are set, then we do not have that division of powers, but the conception could be different. So it's not a question of assessing the individual, but depending on the cases and not the particular judge. Jorge, to which extent the precision, the linguistic precision has to be there? I think the more the language is precise, the better. Of course, there is always ambiguity in language, but we can enlarge or reduce it. I mean, different linguistic expressions have different ambiguities, and the expressions themselves have these ambiguities. No, it's the expressions depending on how we interpret them. So in that division of legal work, it's not only a question of how we formulate the standard or how the legislator formulates the standard, but how the standard is interpreted in a way such as to have the maximum possible precision. If the standard is giving way or rise to very ambiguous norm or rule, it's not useful. I'm not naive as to think that legislator is fixing the words 100%. No, meaning is a result of what we do and what we even do here. I mean, it's a result of the interpretation of jurists and the whole legal community. But of course, there are formulations which are very, very vague, too vague, and others that have more reduced space for interpretation. So as Rajoy would say, the less the better, or the more precise in this case, the better. And I'm not very much concerned about this because I don't think it's going to constrain or limit the decision making by the judge. I think the less the better. And the free assessment of the evidence means that the evaluation of the proof is not predetermined by the law. There are not previous rules. The evaluation of the proof means that in the particular case, which is the degree that the evidence is given to a particular hypothesis. This is part of the assessment of the proof, and this cannot be generalized in rules because the combination of probatory elements is really huge, and we have to determine in the particular case according to the particular evidence that has been presented. But of course, one thing is the evaluation or the assessment of the proof, and something else is when the corroboration level is enough. And this has to be predetermined by the judicial decision, because otherwise there would be arbitrarity and it would not be discretional, as someone said, because I think that a decision without rules, without criteria, without reasons is not something discretional but arbitrary. We are out of time. We have run out of time. I know that Jordi will be there for you during the breaks, so if you want to talk to him during the breaks, he will be there.
For Dale Nance, our next speaker.